Danny Cevallos is watching with us, a defense attorney. Danny, I don't know how much you were able to hear of Gabe's description from inside the courtroom, but did anything stand out to you?
No, because this is an arraignment, and in federal court, an arraignment is really mostly a non-event. It certainly is a significant legal event. It signals the kickoff of the case. It is the beginning of the speedy trial clock. But in terms of what actually happens, most arraignments are measured in minutes, if that. Sometimes they're done in a long list of defendants who have to be arraigned, especially in state court. Less so in federal court, where it's not as crowded. But in this case, I didn't expect anything shocking at the arraignment. There doesn't appear to have been anything shocking or surprising. There's almost nothing surprising that could happen at an arraignment. So limited are the missions of the arraignment, and most defendants don't bother or don't want to have a formal reading of the indictment. So what happens now is a lot of quiet as the cases go, or the parties go back to their corners and the discovery period begins. As the defense assimilates the discovery, examines it, evaluates it, they may ask for more. They may start filing discovery motions. They may start filing dispositive motions. But even those are weeks and weeks, if not months and months away. So the defense, while we have heard glimmers of what they may advance as their defense, they haven't truly started formulating their defense. They can't just based on the indictment. They need to look at discovery. And that, for a defense attorney in a federal case, is often a daunting task because modern discovery, e-discovery, is measured in terabytes. This means thousands, if not millions, of documents that defense attorneys, we have to look at each and every page, even if they're completely insignificant. And it can look like a haystack, and we're looking for the proverbial needle. With Trump, hopefully he can get a team together that can review all those documents, because for a solo practitioner, it can be overwhelming. So they have their work cut out for them throughout the discovery process, which is not something we're going to see in public. It happens behind closed doors, behind the wall of privilege. And of course, another interesting factor is that it appears, although I don't know, that Nauta and Trump likely may have a joint defense agreement, which means that they could possibly be sharing information and retain privilege. Now, here's what happens, though. If one of those people, maybe Nauta, down the road decides that I don't really want to go to trial anymore, then he may have to leave that joint defense agreement if he ever wants to cooperate with the government. Reportedly, Nauta has no interest in cooperating at this point, but everyone knows, prosecutors and defense attorneys alike, that that is only a for now decision. That decision can change over time. As the trial approaches, as this case drags on, defendants who are staunchly, I will never plead guilty, sometimes change their tune as the months drag on.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.